I think that's my cue. We'll go ahead and get started. For everybody in person in the room, it's great to see you. And for those of you attending online, thank you for joining. Because we are talking about hybrid and remote work, we're doing a hybrid session today. So my name is Liz Mellem. I am a shareholder at Parsons Behle Latimer. We're a regional law firm that has 9 offices spread across 4 states. In Montana, we have a Missoula office and a Helena office. So we have approximately, I think we have 10 attorneys now in Montana, around 200 total across the firm. And we do a wide variety of different areas of law. Myself, I primarily do employment work. So I am here to chat with you guys today and help give you some basic information about what's going on in the ever-changing world of hybrid and remote work. Please don't hesitate to interrupt me and ask questions, whether you are online or in the room. My opinion is that the most boring thing that could happen is I just stand here and talk for an hour. So please ask questions. If you're wondering about it, someone else is probably wondering about it, and this is your opportunity to get my thoughts on the issue. So I wouldn't be a lawyer, and this wouldn't be a legal presentation if I didn't give you the little disclaimer that I'm not giving you legal advice. I'm just giving you a presentation about what to be mindful of. This code I'll sit on for just a moment. Anybody in the room, if you want to scan the code, or online, if you want to scan the code, you can get 1 hour of HRCI credit or 1 hour of Montana CLE credit if you are a licensed attorney. So I'll give you all a moment to scan that. It also will be a slide at the end of the presentation too, if you miss it right here. This, I think, is only for live participants though, so if you are watching the recording later on, I don't know that the credit will be applicable, just FYI. All right, so I'm assuming most of you are here because you have either remote or hybrid employees. Is there anybody in the room that does not yet have remote or hybrid employees and is kind of remote curious? Yeah, okay. All right. So these few slides coming up are basically the background of what we're dealing with as employers. So this is a story from NPR from March of 2021. So kind of height of the pandemic. And what happened here was there was a couple who lived in Denver, Colorado. They moved to Minnesota and didn't tell their employers that they moved. Stopping right there, does anybody think that's a problem? Mm-hmm. Yeah, it's a big problem for a number of reasons. Those of you who have to deal with all the administrative stuff in HR, you realize that maybe the payroll withholding taxes need to change. There's unemployment insurance that needs to be considered, potentially workers' comp coverage, not to mention that there may be different labor laws or employment laws that are applicable in Minnesota than Colorado. So first they didn't tell their employers. Then they said, oh, well, we just did it temporarily because of the pandemic, and left out the fact that they bought a house. And then eventually they fessed up and said, no, we really permanently moved to Minnesota. So hopefully nobody attending this seminar has dealt with that kind of a headache, but this is just a partial list of some of the problems that can arise from unplanned remote work when you guys aren't ready for it as employers or as HR professionals. So of course we've got national governments, state governments, and local governments, and they each have power over you as an employer, and they all have laws that apply to protect people, especially employees, and the laws, of course, are not always uniform. So in Minnesota, the employment laws likely now apply to that NPR couple because they are physically located in Minnesota and doing their work in Minnesota, even though they may be doing it for a company that's headquartered in Denver and the company never thought that they left the state. So there's tax issues that come up, state employment and business taxes. There's the question of, does the company now need a Minnesota business license? Is workers' compensation and health insurance going to cover that employee now if they receive benefits? Workers' compensation insurance is a big one, because a lot of policies, at least pre-pandemic, were specific to a state or specific to the states where the company stated they were operating. So if all of a sudden you have an employee that makes you quote unquote operate in a new state, your workers' comp insurance might not cover it. In terms of recruiting as well, will employees still want to work for you if you don't allow them to live where they want to live? So this is just a partial list of all of the little headaches that you can have. But it's a story that's happening all over the country, right? It's part fueled by the pandemic and the significantly increased availability of remote work. I think it's also, at least for me, I'm seeing kind of a sea change in the attitude of both employers and employees on what matters and what is important. And what I hear from a lot of clients is that employees want to live where they want to live, and then they'll find a job that suits them. So this job has to fit what they want and fit their lifestyle, and that may mean remote work. So in Montana, these issues are manageable. There's, blind spots that we have that we want to make sure that we're aware of, and we're going to discuss some of those today. If you have an employee that is located outside of Montana and it's an unplanned situation, that's another matter, right? You are going to want to call legal counsel, call your in-house counsel if you are a large enough company to have it, and figure out what you need to do about an employee that's in a jurisdiction you hadn't realized they currently live in. Here's just some statistics for you about what's been going on with remote work. Since 2020, it says about 2.4% of Americans, or almost 5 million people, say they've moved because of remote work. I was shocked by that. I thought it would be a lot bigger than that. I feel like the news and the issues that I'm seeing in my practice made it much more prevalent in my world. So I was surprised to see that it was that small of a number. Recent polling shows that migration is poised to continue, that around 10% of Americans plan to move so that they can continue working remotely or start working remotely. And that HR professionals who are confident that they knew where the majority of their employees were working declined from 60% in 2021 down to 46% in actually 2022. So that's a pretty big decline, 15% drop in people, HR professionals saying, yeah, I know for sure where everybody is located. This slide is going to be a little hard to see. It's basically a breakdown of people who've been offered the availability of remote work and the prevalence of it, the trends in the remote work growth. So the last number on the bottom right of the slide, the growth in remote work in the last 12 years is 159%, right? So significant increase. So in terms of examples of legal problems in California, who here or online, does anybody have employees who are located in California? Okay. So California employment laws, like the slide says, enough said, they're cumbersome, right? They're hard to navigate. There's lots of variation in state laws related to COVID-19, masks, vaccines, as we all learned. For example, Arizona law also requires paid leave. Montana law doesn't require paid leave, but we also have a couple of weird aspects. One is or two of them are noted here. One is that our age discrimination law does not define age as being 40 and above like the federal law does. So technically in Montana, a worker of any age is protected from age discrimination. That's not a process or a theory that's been heavily tested in our courts. So whether or not it's something that would become cause for litigation is unknown, but it's something to be aware of as an employer. We also, for those of you who hopefully have employees in Montana, you know that we prohibit termination without good cause once the employee has made it through their probationary period. that's the biggest thing that trips up employers, especially during the pandemic. When employers say, for example, it was a company that's headquartered in Texas, they had an employee that said, I'm getting out of here, I want to move to Montana. They said, fine, take your computer, work from Montana. And then they didn't realize that once the employee makes it through 12 months of work for them, they are considered not in their probationary period, and under Montana law, they are protected and you must have cause to fire them. We are the only state in all of the United States that does not have at-will employment. So that's the biggest one that trips the employers up and HR professionals up if they aren't staying on top of it.
Liz?
Yes.
You said 12 months. Why did you choose 12? Like the business?
Sure. Yeah, so 12 months, thank you for asking that. So I mentioned 12 months of a probationary period. That's the default under Montana law. So it used to be 6 months. And in the 2021 legislature, the legislature voted and changed the bill, and the bill was signed into law to make the default probationary period 12 months. So it gives the employer 12 months of discretion to let go of that employee for any reason or no reason at all, as long as it's not discriminatory. However, if the employer has a handbook, for example, that notes that the probationary period is 6 months, the handbook controls. So the default is only applied to an employer if the employer doesn't have some other policy that defines a time. And 12 months is the max. So you can't have a handbook that says, well, 24 months is your probationary period. By operation of Montana law, it'll stop it at 12 months, and that's when the protection comes into play.
I want to ask a follow-up question.
Sure.
And I can't think of a state that it would apply to, but if a company in Texas had an employee manual that had a 6 months probationary period, and that individual moved to our state, does the probationary period start over?
Very good question. For those of you online that may not have been able to hear the question, Christine was asking whether or not if a Texas company has an employee or has a handbook that says there's a 6 month probationary period, and that's just kind of their handbook in Texas. They have an employee that moves up to Montana. Will the 6 month probationary period apply, or will Montana's default 12 month apply? And probably your follow-up question to that is, when does the probationary period start? Those are both unanswered questions under Montana case law. My inclination would say, in order to be the most risk adverse as possible, the company assume the 6 month one is going to apply because you've got it written down in the handbook and that's what your employees know. But in terms of when does the probationary period apply, most likely the winning argument there would be that it applies from the first day the employee works for the company, regardless of where they're located. But there might be an argument that could be made, and it may be successful, that the probationary period doesn't begin until they move to Montana. I don't think that's a particularly strong argument, but it's one that hasn't been tested yet. So these are just examples of additional laws on this slide of things that make it tricky to be in different states all at the same time with different employees. And of course, there's always international issues, right? If you let your employees move to Canada or perhaps, I don't know, Belize or something, then you're going to have to contend with international laws as well. So how do you manage remote employees? The number one thing is just to try, like with your normal employees who are in person at your in-person locations, avoid problems before they arise and take a proactive approach to remote and hybrid workforces. So this is a Gallup poll, this graphic showing work locations for employees who have remote capable jobs. The solid green line is exclusively remote. The solid purple line, I think it is, or blue line, is exclusively hybrid, and is hybrid, and the dotted one is on site. So you can see that actually it's hybrid that is increased, that people are kind of going back and forth between remote and in-person work. So basically what this is telling us, of course, is that employers are increasingly adopting hybrid models. And what does that mean for workforce policies? Is there anybody in the room who does have a hybrid or remote work policy written down in a handbook? Yeah, several of you, great. For those of you that don't, you definitely want to consider adding one because it'll help with with certainty and with planning for your employees. So with your workplace policies, it means you're going to have to comply with multiple state laws, right? You've got to take into account where your employees are located and where you're therefore doing business, most likely. The impact of the new compliance obligation also on your policies and handbooks. I have clients all the time that need to add a new addendum to their handbook. Hey, I need a New Mexico addendum. Hey, I need a Pennsylvania addendum now because, you know, so-and-so is moving there. Some people choose to add it directly into their handbook and they have little writers, but it's all what's best for the company, what makes the most sense for the company at the time, and what's most helpful to them administratively. So we're going to go through a couple of best practices for managing your remote or hybrid employees. Of course, you want to update your policies and your handbooks to make sure that you have a policy about remote work rules. I could give an entire 1-hour presentation on just what that policy should look like. But it's going to include things like making sure that, you know, consider whether or not you want to make sure they're on camera on meetings once a day or once a week, because you want to see what they're doing. Consider whether you are going to be the type of employer that has perhaps monitoring software on their computer to know when they log in for the day. And make sure that you've got disclaimers and notices to your employees that you have that kind of software on the computer. You also want to consider if you want to make rules or requirements about where they work. So do you care? Do you care if they work at Starbucks for the day? Do you care if they work on the beach for the day? Are you going to want your attire policies, your work clothes policies to apply remotely? Do you want to make sure they have a secure office where they can close the door away from their kids, their dogs, their cats? We've all seen the cat walk across the keyboard in this remote work and Zoom world. You also want to think about access to your company information. You know, are you going to require that they're locking their computer every time they walk away so that one of their kids or someone else doesn't sit down and try to use it and inadvertently get access to your company information? So there's quite a few different things to think about that you'll want to sort your way through and understand what's important for your company or not. You also, of course, want to keep track of where your employees live. It would be best to require notice of and permission for them to move out of state before it happens. You may end up like the company with the NPR article where you have people just up and leave and they aren't completely forthcoming with you. A strong handbook, strong policies are going to protect the company to give the company the discretion whether they want to retain those employees or potentially use it as grounds for termination because of a violation of a policy. When you're giving offer letters, you want to work on conditioning the employment on your right to decide whether the employee can work from anywhere. So if you are the type of company that gives offer letters, make sure that you have information in there saying that the company gets the final say if the employee is going to relocate on whether or not the employee can stay with the company and do that. Know that ignorance is not a defense. So if you allow remote work, you need to learn about and comply with applicable laws in those jurisdictions. So I already talked about offer letters and remote work agreements. You also want to frequently check in with your remote workers to verify their location and compliance. And be prepared to end relationships with workers who move to places that aren't working for your company. We'll talk about this at the end, towards the end of the presentation, about how you terminate someone remotely. But this is a huge bullet point, this be prepared, because what do you do if you are a company that's based in Montana and you have somebody working from Florida and you need to fire them on the spot? What does that mean? So we'll talk about that as we get through the presentation. ADA accommodation requests and remote work. So before I move on to this topic, does anybody have questions about what we just went over? No? Okay. So in terms of the bare bones basics, ADA is the Americans with Disabilities Act. And so this would be a situation where an employee is coming to you and saying, I need to work from home because of X disability. So it happened a lot during when we were at the height of the pandemic, people saying, I am immunocompromised, I can't come into work, I need to be able to work from home. It happened, it still is happening or can happen where somebody, maybe they have a mental health issue that requires them to work from home or that they believe requires them to work from home. So this is going to be some tips on how to navigate those requests. So the very first piece of it is that under the Americans with Disabilities Act, you don't need to excuse an essential job function in order to accommodate an employee. So basically what the American Disabilities Act, and I'm making this as simple as I can. Please know that this is a very complex and layered area of law. But essentially what the act says is that if somebody can do their job with or without an accommodation, the company needs to work with them on an accommodation so long as it doesn't create an undue burden for the company. So basically that means if you have somebody who can't stand as a cashier for long periods of time, you might allow them to sit on a stool while everyone else has to stand. There's a whole process you go through with getting medical certification and working with the employee to find out what accommodation fits. And we're not going to talk about that process today because again, that's a topic that can take forever. But know that if something is an essential function, you don't have to cross that out as being an essential function just to accommodate someone. So if on-site work is essential, you don't have to excuse an employee who can't come to on-site work because of a disability, but you might need to provide other accommodations. So a very basic example of this would be you run a grocery store and you have an individual who's an overnight stocker, meaning that they stock the shelves, they're, pulling all the goods out. On-site work is essential there, right? That's not a job they can do from home because they need to be physically in the space, they need to be touching the merchandise and putting it in the right places, scanning it, all of that sort of thing. If they tell you based on whatever disability that they are unable to come to work. For example, say they come to you with doctor's information that they have some sort of a mental health issue, let's say PTSD, that they can't work at night and they can't, they can't work in close quarters. They need to be able to work from home. Well, working on site is an essential function of the job, so you don't have to excuse that, but maybe you can shift when they work to have them stock during the day instead of at night, or stock in a different area of the grocery store than where they had been previously assigned to help accommodate them. So it's thinking about being creative about possible other accommodations, but not having to necessarily be forced to let someone work from home. You want to make sure, you're going to have employees that say, well, my work, I don't have to be at work to do my work. The pandemic proved that. Like I worked from home for months and everything was fine. And you want to make sure that you are prepared for those types of those types of arguments, and that you have, job descriptions and policies ready to go to say why the on-site work is now essential, if that's what it really is. So what I'm not saying here, but I'm going to say right now, is to document everything. The golden rule of risk management when you are in HR is that if it is not in writing, it didn't happen. And this is the number one issue that I see whenever I have to deal with clients who are in litigation. And I like to tell them that their HR records are either gonna make them or break them. That's a really rudimentary way of saying it, but essentially, if they come to me and say, oh, you know, we talked to this person 5 times and, you know, we've been working with them forever to try to get an accommodation in place. If I don't have paperwork backing that up, even just emails, it's not going to be helpful to defend the employer against a claim that they haven't been working with the employee. So make sure that you are documenting things, writing things down, even if it is just emails that are being sent, but that are being maintained. So we're going to go through a really quick case study here so you guys can see how this applies. This is a case from 2002 out of the 8th Circuit. And this is Joseph Mobley. He worked as a patient access supervisor for St. Luke's Hospital System in Kansas City. He supervised a team of customer service employees who assisted patients with insurance questions via the telephone. So it seems like something you could probably do from home, right? You're just talking to people on the phone, you're not in person. But like all other supervisors, the hospital required him to work a hybrid schedule, 3 days on site and 2 days remote. And they wanted him on site to supervise so that he could be, you know, with his team. Well, he suffered from MS, multiple sclerosis, and he asked for an accommodation of additional time at home during his MS flare-ups. So he wasn't asking to go completely remote. He just wanted to have the ability to have more time at home. The hospital denied his request on the ground that on-site work was essential for him to effectively supervise his team. But they did offer him an alternative accommodation and said that, you know, if you're having a flare up, go ahead and leave. When you need to go, you know, leave when you need to. What do you guys think about the situation? Are you comfortable with the fact that the hospital denied their request? Are you comfortable with the accommodation? I'm curious what you guys think.
I think the accommodation is fair.
Okay. So Holly's saying the accommodation is probably fair. Are you comfortable with the fact that they denied his request initially? Do you think on-site work is essential?
That's a gray area.
Yeah, it's a big gray area. No one has the right answer except for the 8th Circuit, right? So of course he resigned, sued his employer, and he alleges that they failed to accommodate him, his disability as required by the ADA. The hospital said, you know, enter summary judgment. That just basically means we win without having to go to trial. They wanted all of his claims dismissed on the grounds that 1, on-site work was essential, and 2, they had provided an alternative leave accommodation. In the trial court, the first court that they were with, the district court sided with the hospital, and they said there's no continuous pattern of discriminatory conduct or a change in job responsibilities, and so you're good, hospital, go ahead. But of course, Mobley appealed. There was a mixed ruling on appeal. So the 8th Circuit rejected the hospital's argument that on-site work was essential. They noted that the hospital offered just its own conclusory opinion that it was essential and failed to provide evidence that Joseph could not effectively perform all those other essential functions remotely. So something to keep in mind in terms of bolstering whether or not a qualification or a function is essential. So this is a quote from the 8th Circuit just saying that allowing him to consistently work remotely, aside from his medical condition, the hospital implicitly demonstrated a belief that he could perform his essential job functions without being in the office all the time. He continued to receive positive performance reviews while he was working remotely, and that reflected that he was able to effectively supervise his employees despite not being on site. So that's a situation where the employer's records and documentation kind of broke them in that they had been documenting that he'd been really successful working remotely, and it wasn't maybe necessary for him to be there in person. But the court ultimately still found in favor of the hospital because it agreed that the hospital had provided an appropriate alternative leave accommodation. So the hospital ended up still winning in this situation because they've given the accommodation saying you can leave whenever you have a flare-up. But it's a, lesson to be learned about the process with the employee and the allowing remote work and what type of history or precedent that can set for your employees. So takeaways: if you provide a hybrid schedule of telework and on-site work, you might face a steeper challenge to deny an ADA accommodation for additional telework. If you deny a telework accommodation because you deem on-site work essential, you need to document the specific ways that on-site work is essential. That's an area where St. Luke's Health had not fully done that. Better yet, plan ahead by documenting the essential nature of on-site work in your job description. So the job description is one of it's like exhibit 1, 2, or 3 in an ADA accommodation case. So having strong job descriptions that clearly set out what is required of your employee, what their qualifications need to be, and what their essential functions are is something that'll be a little bit of a safety net for you to fall back on later on, depending on the issue that pops up. If you provide a provisional telework accommodation, so just for a short amount of time, make sure you document that you are temporarily excusing some essential job functions and give context for that in performance reviews. So, for example, with Mobley, they might have said, Mobley has been spending more time working remotely lately due to a health condition. We have temporarily allowed that to occur, and we know that he's doing a good job in this temporary arrangement. Rather than just being like, he's great, doesn't matter if he's in here or not in here. So would have been a little bit better documentation for them. And then make sure you're analyzing alternative accommodations, including leave or reassignment to a vacant position before you finish your accommodation analysis. The law doesn't require you to come up with a brand new position if you don't have one available. But if you do in a department that's the equivalent and you can transfer the person and they're open to that, and that's a work from home position, that's certainly something to be part of the conversation. So what about workplace harassment in the remote area? Everybody's favorite topic. So with everybody teleworking, at least we don't have to worry about harassment claims as much, right? Wrong. You guys like my graphics? I'm teasing because, it's a PowerPoint, it's graphics. But I do have a fun Hamilton picture on this one. So over half of HR managers surveyed in a specific survey that we looked at said the reports of harassment had increased during the pandemic. And numerous surveys have shown this. So respondents to 2 different surveys, the Purple Campaign and Project Include, reported a 25% increase in gender-based harassment during the pandemic. And one also showed a 23% increase in age-based harassment of workers over 50 and 10% increase in race-based harassment. A Deloitte survey revealed that over 50% of women reported experiencing some form of harassment or microaggression in the past year. The likelihood, of course, increased with the intersectionality of another protected characteristic, such as race, age, sexual orientation, that sort of thing. It wasn't necessarily only based on sex or gender. So what's causing this? There's, increased communication in one-on-one settings, chat, text, email, phone. We don't have everybody out like in cubicles or with office doors open, right? It may feel like no one can overhear, so they can get away with saying or doing things they may not have in a different context. Zoom or WebEx or Teams may also reveal private information. So think about the background when your employees are on a Zoom call. Is that showing their religion or their national origin or that they may be in a same-sex relationship based on perhaps what's on the wall behind them. So I do know of employers who require people to be on camera, but with their background blurred, or partially for that reason, but also just to help the employee, have a sense of a little bit of privacy, even with the camera on. Employees, it could also be because employees are more casual in conversation, saying things they wouldn't have felt comfortable with saying in a physical office. I mean, think about that. That makes sense also from a work dress standpoint, right? There's a lot of people, myself included, that if you work from home, you're going to make sure that this looks professional, but you might have pajama pants or jeans or something on the rest of you that you wouldn't normally wear to the office. I saw a picture the other day of a company that actually did a wear to work what you wore at home during the pandemic day. And it was really funny to see the pictures that were on, because it was a lot of, for example, men, it was like them in blazers with ties, and then they had like these gym shorts and slippers on. And, I mean, it was just really funny to see the difference there of what's happening. But it's that type of mindset, right? That if they think they're in a casual conversation because they're from home in a casual or private setting, they may not realize that that is a work setting during work hours. There's also potentially a lack of personal connection to colleagues that they've never met in person or haven't been in the office together with for an extended period of time. So if you're onboarding somebody new remotely and you have another person who's been with the company for 5 years, and maybe that person who's been with the company for 5 years has a quirky personality and everybody else knows it, that new employee might not know it. And there may be issues with communications right off the bat when it's all being done remotely. There's also the heightened stress of the pandemic. 85% of workers surveyed reported increased general anxiety. Email, text, and chat communications make it harder to decipher tone and intent. I'm sure everyone that's listening has heard that before or experienced that, right? You get an email and you're like, I don't think they meant to say it the way that they said it, but maybe it's that they didn't intend for you to take it the way you're taking it. There's two people at least on those communications. And when it's in writing, if you don't know the person it's coming from, it's a lot harder to feel out what they really mean if they aren't communicating clearly. Also, the quick move to remote work left a lot of employers unprepared for the challenge and unprepared for how to deal with the situation. So these are just basic examples of what harassment might look like in a remote work setting. So sexual or otherwise offensive comments in chats or texts, comments on a private social media account. This is a big deal in the Fifth Circuit right now. You guys may or may not have heard about it. It's the airline case. And this is 2 airline flight attendants for, I want to say it was American Airlines, and I could be getting that wrong, but one of the large airlines. One sent the other very tense messages about the other ones, like woman A's posted a bunch of picture of her going to the Women's March after the 2020 election. Woman B was very offended by this and sent messages. Woman A replied in those messages. And then one of them, I think it was woman B actually, was disciplined at work for the private messages that they were sending back and forth. And now it's gone up, it's at the Fifth Circuit at the moment on whether or not that harassment, one of the many issues, whether or not that harassment really was work-based harassment when it was done on private social media. So be aware of that. There's berating employees in front of others in online meetings or sharing links to inappropriate content. I just had this in an investigation I did a couple months ago. One of the claims was that the individual who was alleged to be the harasser had sent a YouTube link And when the individual who was alleged to be the victim opened the YouTube link for the, I think, honestly, if I'm remembering correctly, it was like a Rickroll link to the, Rick Astley song. But the individual who was alleged to be a victim said that there was a pornographic ad that came up first, and then the YouTube clip played. So things like that, you may, as the person who is the alleged harasser, never have intended that to happen, but now it's tied to work because it went through work email or it went through the work Teams chat. Taking screenshots of colleagues during meetings or disrupting them with inappropriate captions. Has anybody dealt with their workers taking screenshots of other people on meetings and using them?
Yeah.
Yeah. In a like funny, positive way or in a troublesome way? In a troublesome way. Yeah. So again, it's that type of stuff that you didn't think about when you all worked in an office or in a building together and you weren't on screen all the time. So what do? Make sure your company policies are revised to expressly apply in remote work situations. So you may have a very good harassment, anti-harassment, anti-discrimination policy, but look through it, make sure it applies to remote work situations. Address what professionalism looks like in remote work settings. So consider a standard virtual meeting background. There are companies, like I said, that allow everybody to blur their background or ask that everybody blur their background. Maybe you have one that's developed for your company so that every time I come online, I've got a Parsons Behle Latimer background. You could institute that for your company. Consider also dress code expectations, making sure employees know that those apply in settings online. And of course, appropriate document retention on company-owned devices or systems. So this is making sure stuff's not being deleted by people who are working remotely and that it's being properly retained for the company. You also want to make sure that your harassment training, which hopefully you are doing annually, evolves to reflect a remote work environment, and that your examples of harassment, examples of things that should be avoided include remote work scenarios, and have a focus on bystander intervention, ways that people can say, look, I'm not comfortable with what you just said in our Teams meeting. Can you please make sure not to use that kind of language in the future? Or something similar to that like flags for the individual that what they were doing was wrong or could be problematic. You also want to minimize obstacles to reporting. So recognize that if people have never been in the office, they might be hesitant to contact an HR person they've never met in person. So consider whether or not you want to have multiple avenues for reporting, whether that's a phone call, whether that's like a ethics hotline, or whether that's a website. There are plenty of them out there that you can subscribe to as a company so that people can anonymously report and then it gets shuttled to the HR individual. Okay, last section. I think we're kind of on time. We've got about 15 minutes left. Does anybody have any questions about the harassment stuff before we start talking about terminating someone who works remotely? Are there any questions online? Nothing coming in the chat?
Not at the moment.
Okay, we do have Christina monitoring the chat. If anybody has a question that they want to ask online, please feel free to put it in there, and I will do my best to answer it while we are talking. So, what do you do when you want to terminate someone who works remotely? Well, of course, you want to follow applicable state laws and the federal laws too. So, like I was saying earlier, it's important to know that different states require different things, even when you're terminating an employee. Our focus is going to be on Montana, but know that Montana is unique, and it doesn't necessarily mean that that's the same thing you do in Idaho or Nevada or New York. Of course, you always want to document the reason. I should have brought a prize if somebody could tell me how many times I use the word document in the presentation. But you'll hear that from me if you ever see presentations repeatedly from me. I tell you over and over to document things. Make sure you're documenting it as the reason for the termination, as well as any issues that are leading to the termination. What I hate to see as a defense attorney is someone call me up and say, we are going to fire Susie today because she is late for the 10th time this month and she has not been changing her behavior. And I go, okay, hold on. Like, can you send me the 9 other either verbal, documentation of verbal warnings you gave her or the written warnings? Well, she knows. We've told her. She knows. Okay, but you don't have any documentation of it? No, but she'll know when we tell her that, she's fired for being tardy. You may think she knows, but she has she's gonna have a fun time walking into a plaintiff's lawyer's office saying, they never told me. No one ever told me I needed to be on time and I was never in trouble for it. And then all of a sudden they up and fired me. So make sure you have the documentation to back up what your decision is. And then there's practical issues, right? So what company-owned equipment or hardware does that employee have? And how are you going to get it back? Because as the employer, you can't just go busting into their house to grab your company property. You also, in Montana, you cannot hold their final paycheck hostage pending return of that equipment. So you still have to pay them their final paycheck, even if they have not given you back your computer, not given you back the phone, they still have the printer, whatever it may be. And are you keeping an inventory of what they might have that's company owned? Do you have an IT department or a facilities department, or just, maybe it's also on your HR person's shoulders, but do you know which computer they have, how long they've had it, whether they're running updates on it, all that kind of stuff. Are you prepared to flip the switch and immediately shut off the remote access to all of your systems and programs? Because this isn't a situation where you say, you're terminated immediately, let's walk to your desk, I'll help you gather your things and walk you out of the building. That was really a lot easier in some ways to do pre-pandemic. Now you need to have admin protocols for how you can properly either block or remove access and disable email addresses, logins for Slack or Teams or whatever. I mean, QuickBooks, if you fire somebody from your accounting department and they have access to your finance software, make sure that they can't get into any of that remotely. And the part I'm not saying here, think about the logistics, right? If you have, Madam CEO is going to call that person and fire them. Is there someone that's flipping the switch right when they get fired? Or are you going to do it, 3 minutes later? Or are you going to do it 3 minutes before? And they're calling IT going, why can't I get into the system I'm trying to get in? So think about the timing of things as well. How are you going to protect and retrieve any of your proprietary or confidential company information, especially if there's a risk that the employee may have downloaded some of it? So is your confidential information secure and protected? Is the company able to harm, delete, or copy that data before their access is revoked? Think about those things and how for you that applies for your company. And then are you prepared to pay out the employee's final paycheck per state law? So in Montana, if you don't have a handbook that specifies that they're going to get paid at X time, usually, in the next regular pay period, that final paycheck is due within 24 hours. So you're going to have to cut it quick and get it out to them. Have you made arrangements to pay out their earned or accrued PTO with the final paycheck? I've just asked the question here, and I haven't put all of the 97 caveats in Montana law about this. It is a fraught area, but the best, most risk adverse position in Montana is to pay out the PTO balance they have. It's very easy to get tripped up as an employer because Montana's law is we don't have use it or lose it available for employers. So you can't, for example, give somebody 20 hours of PTO and at the end of the year, if they have 5 hours left, it wipes down to 0 and they start over. That's not okay under Montana law. So be careful there and know what you're dealing with. Ta-da, we ended a few minutes early. Here's the code again for credits if anybody needs it. Are there any questions that I can answer for anybody? Yes.
In terms of working from home and safety, what are some best practices like when the employees wearing their slippers with the bunny head on it? They jiggle over their dog and front themselves.
Great.
Yeah, so what kind of
Great question. So for those of you online, if you didn't hear, she was asking about safety when the workplace is at home. And you may have an employee who's wearing like their bunny slippers and they trip over their dog and injure themselves. It's a fantastic question because the fact pattern you just gave is fraught with issues, right? Was that really a work injury or was it not a work injury? Because, where did the accident take place? So those are all the types of things that why having a policy about remote or hybrid work in advance, or even having an agreement with the employee about that kind of work will help define that. So you can say, you're required to be appropriately and professionally dressed for work. You're, required to do your work in this specific area of your home. Like you have volunteered to us that you have a spare bedroom that you are going to set up as a home office. We expect all of your work to happen in that home office. So that later on, if you find out they tripped in the kitchen or that they tripped in the hallway, you might have, you or your workers' comp insurer might have an argument that it wasn't actually a work injury. But those are the types of things that you can try to handle in advance by having appropriate policies so that your employees know what is expected of them.
And work comp also recommends that you have photos of that workspace. Just have them on file, so that when an injury does occur, you're not trying to shoot that down and hold it back there. So you have that established, like, oh, this is what the employee says is their.
Good point, Holly. So for people online, she noted that workers' comp insurance usually recommends that you have pictures of the workspace that they're using at home so that you have it documented and you're not trying to track that information down later after an injury has already occurred. Brian, did you have a question?
I'm curious to know if anything nationwide. I'm assuming on something that will darken my day someday, darken my door someday, which is you get a supervisor who comes in and says, I've got a remote work employee who's not been interacting with our systems sufficiently, and that's how I know they're signing off. But they haven't intervened. It's been weeks and months, and without getting into the I deal with public employees, so a lot of vulgarity. I don't know if you can leave determination without curtailing the remote work first. And I'm just curious if you have any prior examples of employees not interacting with the systems as evidence for disciplinary termination.
Yeah, so if you have somebody that you suspect is underperforming because you're not seeing them log on when they need to log on, or they're not responding to emails in time, or maybe they're supposed to be, sending out work product in a specific format or a specific software program and it's not happening, that you just need to start documenting it. Whether it's emails to the employee that says, hey, per our agreement or our policies, we can monitor your access to X, Y, and Z software. We see you haven't been logging in. Please let us know if there's anything we can do to help. Remember, your performance review is coming up, those kind of things, and then document it in performance reviews. Because what the nightmare scenario, of course, is that the employee comes back and says, well, I've been dealing with this health issue that now requires, additional accommodations, or is because of remote work, or who knows what. But they give you some alternative description or reason for not logging in and not being productive, and you haven't been documenting it. So even if it's just emails to the employee asking what they're doing, or requiring them to have, every day, a 15-minute video on call with their supervisor to check in. I have clients who've done like weekly check-in meetings with supervisors where if they have somebody that doesn't seem to be putting out the work product they need to put out, the supervisor's meeting with them every Monday morning or every Wednesday afternoon to double check how things are going and help encourage them. But the primary reason, or the primary thing there being that you want the history of documenting that they're not working or they're not productive, so that when you need to take a step either to suspend them or demote them or fire them, you have the documented history of why you're taking that step. Make sense? Okay. Yes, question.
So what do you recommend for like policies for company owned equipment or data? I had a client where their ET was planning his departure, and didn't actually end up getting fired, like left the day before he was gonna get fired. And
Okay.
there's all this stuff that's missing.
Yeah,
Including records of bank accounts, like how, I mean, that was a disaster.
yeah.
But how would you proactively, prepare for that?
Yeah, so one of the scenario you brought up, for those of you online, if you didn't hear, she's saying, how do companies protect their data and their equipment ahead of time? So you don't have the nightmare scenario where you've got an executive director or CEO or a CFO or even an HR person who has been downloading or planning to exit and has been taking information with them. And then all of a sudden they log off and say they're done and you can't get to the information. So of course, the number one, like the first step is to make sure that there's a clear policy in the handbook saying, the company's data and equipment is the company's property. The employee cannot take it. You have to honor confidentiality after you leave, whether that's voluntary or not. A second line of defense there is if it's someone high up, because I've seen this happen, and it, for whatever reason, it tends to mostly happen in nonprofits who don't have the money to have like IT people or others, is making sure that there are good system processes that are basically checks and balances. That not all of the power is in the CEO's hand or the executive director's hand, or not all the financial information is only in the CFO's hands, or they have all the passwords to the bank accounts. There needs to be backup or redundancy. I had a situation I dealt with about 6 months ago where a key employee, not an executive director or anything, but a significant employee, had put in their resignation and said it was effective immediately and logged off, and the higher ups in the company went in and realized that that person deleted a bunch of stuff out of their drive, their shared drive they were using, changed a bunch of stuff to like gobbledygook, like clients' names and things, like removed vendor information, that kind of thing. So then the company is stuck trying to decide, okay, well, what are we going to do? How do we recreate the record, first and foremost? And do we sue? Like, do we try to, get some sort of damages out of this person or get the information back? And that's never a place where a company wants to be. So on the front end, having some sort of system or access that perhaps sends a flag to an individual that says, to the HR person that says, hey, Johnny changed this record today, FYI, or you have an IT person, even if they're a contracted IT person that can monitor things for you, or that can go in and maybe see if deleted files can be recovered. One of the biggest issues in this scenario was that the employee had gone back in and deleted all of the Slack messages where that employee had been using very questionable language and, quasi-abusive language towards others, but had left all of the responses that came from people who, when they were heated and sending their responses. And I learned through that process that if you don't have that flip switched on Slack from the beginning, you can't go back and get the data. Once it's deleted, it's gone. So there's different softwares that have different parameters where you can't claw things back. So just knowing what software you're using, what its capabilities have, it's a lot of upfront work, but will help in the long run both protect that data and potentially give the company the ability to go after the individual if they need to. Yeah.
Different question with the flexibility that comes with remote work. Sometimes people are driving about during work hours for personal purposes.
Mhm.
doing their work in the evenings or whatever. If somebody is injured in an accident while they're at work, but obviously not at work, where does the liability on that fall? And how do you as an organization create parameters around that?
Yeah, it's another great question, for people online. It's about, individuals who are supposed to be quote unquote at work, but maybe they, are driving to the grocery store and they get hurt while they're driving, in an accident or something, and that's not a work related thing. How is that handled? What does liability look like there? And I'm gonna tell you just straight up, it depends, the standard lawyer answer, right? Because there's a lot going on in that scenario, my first question would be, well, was that an hourly employee or an exempt employee or a non-exempt employee? So if it was an exempt employee who is, is hitting those Fair Labor Standard Act exemptions, isn't required to track their time, isn't required to, get overtime, then we've got one set of arguments. But if it's somebody who's on the clock and they're doing non-work stuff on the clock, well, then you've got a theft of time issue. But if they weren't on the clock because they clocked out to go to their lunch or go on their break, which you still want to make sure to give people if your company allows for breaks and the like, even if they're working remotely, then they're not on company time. They went and were doing a personal thing. So there's a lot baked into the scenario you gave that makes it no clear answer until we know what the facts really are. Make sense? Other question?
Are there any rules in Montana that require employers to reimburse employees who are 100% remote or hybrid for the utility?
You asked a really hard question, Kylie.
I know, I'm sorry.
Okay. I know.
On TikTok.
I know, so she asked, is there a law in Montana that requires employers to reimburse employees who are either 100% remote or hybrid for their utilities? The short answer with a giant asterisk is no. But there's a huge asterisk there because there's this funky law in Montana that an employer has to provide all of the essential or necessary equipment to do the employee's job. Like most things in Montana, that hasn't been thought about in the court. So we don't know what necessary means. We don't know what essential means. We don't know what, do your job means under that law. So is it just the big stuff like a computer? And wait, does that mean you pay for their internet access and their electricity? Or is it all the stuff? Is it you have to pay for a printer and the paper that goes in the printer and the ink? Do you have to pay for the pencils they use and the notebooks they write on and the Post-its that do you have to pay for the chair they're sitting on? What if they're at their kitchen table? Are you supposed to pay them some sort of value for their kitchen table? It's a huge unknown in Montana law right now, that I've kind of been waiting for it to be heavily litigated because of the remote work thing. But I think it just hasn't come to the attention, frankly, of plaintiffs or plaintiffs' attorneys, that's an area that they could set some law. Yeah.
Would it depend on whether or not a worker was working voluntarily remotely or required to be working remotely?
That would be a fantastic argument saying, if they chose to work remotely, then yeah, your first line of defense is to say they don't have to do that.
Right.
Like I'm providing them everything they need to do their work in the office, but they're choosing to do it somewhere else so they can make that work for themselves there. If they're required to be remote or they're approved to be remote, it's a different story. Other questions? Are there questions online at all?
Nope.
Okay. Well, we've run a little bit over. Thank you guys very much for coming. I appreciate it. Let me know if you have other questions. I'm happy to chat.